Good afternoon, Marlene. Hello.
Yeah.
Live.
Good afternoon. Thank you for joining us live. My name is Marlene Elliott, and I am the staff attorney for the Community Economic Development Microenterprise Program at Legal Services. Today, we are discussing the topic of legal issues facing businesses as they reopen. Presenting today is Tracy James, the managing attorney of the CED Microenterprise Program at Legal Services. There are a couple of points I'd like to make before we begin. If you have a question, please feel free to ask it in the chat. Tracy will try to address your question at the end of the presentation. Please do not share personal details in the chat. Also, please note that the information provided is legal information, not legal advice. If you miss any part of this presentation, don't worry. A recording of this video will be available on our Facebook page after the live stream ends. Additionally, the slides from today's presentation will be available on our website at lsem.org/COVID-19-updates. The Microenterprise Program offers free legal assistance to those who qualify and who want to start a business or nonprofit here in Eastern Missouri. We offer legal clinics, presentations like this one today, and help clients with their legal needs as their attorney. Near the end of the presentation, Richard Sisson, the CED Microenterprise Paralegal, will briefly discuss how to become a client. I will now turn the presentation over to Tracy James. Tracy?
Thank you so much, Marlene. Thank you, Richard. Today, we're going to talk about some things that are very current and has some relevance to those that run businesses, nonprofits, those that are employees as well. And so this will be hopefully timely and fast-paced, and I apologize because there's a lot of information to cover in a short period of time. So basically, what we're going to be talking about today as part of our roadmap is one part of this. The first part is talking about the steps to reopening your business safely. Now, I use the word business loosely because it could be a nonprofit, it could be whatever your enterprise is if you're a business owner. And so we're going to be talking about guidance. We're going to be talking about law. We're going to be talking about those things that a lot of information that's going to, we've been encountering in the news about what should we do about reopening. We're also going to be discussing briefly about creating and updating your rules and policies if you have them for your workplace so that your staff can come back safely and that you can eliminate the COVID-19 virus that seems to still be affecting us deeply daily basis. We're also going to be talking about OSHA rules and some of the things that you will need to follow that is based on your type of workplace as well as the industry that you're in. And then the second part of this is going to be talking about avoiding staffing issues due to the COVID virus. Yes, you might have a great workplace that it's ready to go. You're practicing social distancing, all of those things that are required. But maybe your staff are still quite nervous about returning. And then what do you need to do to avoid getting yourself in hot water and hurting your business and hurting your relationship with your staff? And also making sure that people do not catch this virus. And also you want to avoid discrimination and liability, as well as helping those that are considered high risk so that this is an easier return to work decision. So first of all, getting back to normal in the workplace, what exactly does that mean? I don't know if there's really anything that is normal anymore. I don't know if we will be going back to normal at all in the near future. So this is also, this is the new normal, I just don't know. But I want to make sure that we're all on the same page as in terms of definitions, because I'm going to be using some of these terms interchangeably, and for the most part, with some exceptions, they can be used interchangeably. So worker, independent contractor, employee, volunteer, staff. For the purposes of this presentation, a few provisos, that we're going to just be using them as the same thing. So depending on how big your staff is or how small, this would still should still be able to apply to you. Okay, so there's been a lot of information out there ever since we found out about the virus. And so one of the things that I would recommend highly to do is that you rely on the law. What exactly is the law? Well, we'll talk about that. So there's going to be different categories of what you should follow, okay? Must follow versus should follow. So first of all, the law, you must follow, right? Now, regulations come under that, and that's the laws made by, if you remember, civics or government. It's passed by Congress or the legislature, and it becomes law signed by either the governor or president, depending on what that is. And then the applicable branch or department has these regulations that are interpreting the law and how they see how things are going to work out. And so then based on that, there's also guidance, which is basically the best practices, what the protocol should be, or that you should go ahead and follow. So we're going to be kind of exploring this in the first part of it and trying to understand what exactly does this mean? Do I have to follow everything? Well, I don't know about that, but you want to make sure that you rely on the law, you follow the law first, but then you go ahead and follow guidance once we understand this. So basically, guidance is not law. So to kind of understand emergency orders that we receive, let's say there's an executive order from the president, that is law. An emergency order from the county or from the state or from your municipality, that is law, you must follow. Now, with everything that's going on, and because the virus happened upon us so quickly, those people who are putting together the guidance that is based on the law, the regulations, might not be able to answer every situation. They might not know the answers, but it's changing a lot. So it will be really important for you to kind of keep a good finger on the pulse of what's happening, being aware of the news. So you have emergency orders that are law. The CDC, I'm going to use a lot of different acronyms. I'm trying not to, or alphabet soup, but the Centers for Disease Control, the state and county guidelines, that is guidance that is probably based on what the law is, but it's guidance. That means maybe you want to go ahead and follow it, all right? Now, OSHA, which is the Occupational Safety and Health Administration, that is an agency of the Department of Labor and Executive Branch, that has relies on both law and guidance. So when you're trying to put together your toolbox of things that you must have, most probably look at your state and county guidelines or your orders, what the emergency orders are. Look at the guidelines from the state and county. Look at the guidelines from the Centers for Disease Control, and also look at OSHA, because they will have particular guidance on making sure that your employees are safe, because OSHA is that agency that protects staff and making sure that during this virus that they're taken care of. So again, emergency orders are law, and I put up here based on just 3 counties that, and also the state, that have the orders. And when you see these orders, and hopefully you'll be able to hyperlink them when you get this. When you see this, make sure I have this right, that this is law that you must follow. So when you actually look at what the law says, and I'm just looking at businesses here, not individuals, okay, because there's something specific on businesses. They do not generally have a lot of information. I just put in some things about restaurants and daycares and childcare, what I was able to find from the state of Missouri Phase 1 recovery from their website. And then again, that order ends on May 31st. And so hopefully, if we have not already gotten it, receive from the state what the new order is, because this one will expire on Saturday, if I'm not mistaken. So businesses in general, you have to keep 6 feet in distance between workers. And if part of the functions, if they're closer than that, you have to have enhanced precautionary measures, which we'll talk about. So this is very general. They talk about retail that's less than 10,000 square feet. no more than 25% full, according to either the fire code or the occupancy limits for your municipality or for where your jurisdiction. Retail, greater than 10,000 square feet, like let's say a much bigger store like a Best Buy or something, no more than 10% full of what the occupancy is. And then they have some specific things on law for restaurants and daycares and childcare. So this you can offer, this is just a state. And so this is kind of what they are saying as what you need to follow, that if you're going to be a restaurant and you're going to open dine-in service, that you have to have 6 feet between the tables, lack of communal seating, and no more than 10 people at a table. You limit self-serve choices. You have paper menus, disposable menus, and that staff must use personal protective equipment at the very least, which would mean masks and probably gloves and maybe other things, just depending on what they're doing. And then daycares and childcare can open, according to the state, if and they can provide childcare if they're following the CDC guidelines. So that's very general stuff, and it's only talking about a couple of different industries. So the recovery order is phase 1. So this is also what they're trying to say. If you can mention that about the 6-foot essential job duties. Barbershops, salons, tattoo parlors can open if they follow the CDC guidelines and local health and safety measures. All right, and so that's what we're also going to talk about. Encouraging delivery options rather than in-store as most possible. Limit people in a waiting room. If you have people congregating, you might want to have them do that outside and have them made appointments so that when they're ready, you can have them call in. It's like curbside service, right? So they can come in one at a time to eliminate any problems with social distancing. And then again, gyms and pools can open if they follow strict social distancing and sanitation protocols. So that's the law. Okay, so that gives us a little bit of information and that we must follow for the industry, but what exactly does this mean? So I've used a sample one, it's non-inclusive, from the city of St. Louis. And so I just kind of used some different things. So you look at the retail. So like the city of St. Louis, just like the state, just like the county, they have one for each industry. So they have like office 1, office 2, retail, factories, all these different areas. So you want to go ahead and take a look at that depending on what your industry is, what your business is. So for instance, I just kind of picked out retail. Use gloves when handling garbage. Have enough soap and cleaning supplies. It's at least 70% alcohol or plus. Staff must wash hands 20 seconds at 100 degrees plus each time they touch their face, their sneeze, etc. I know I just touched my face a few seconds ago, and most likely I'm probably going to have to wash my hands for 20 seconds. Ask customers to put things in a tray or counter and wipe with them. So you see those things here. Offices, as they reopen. Now these are, again, law. You must follow. Have an office entry one way in and another out. No non-essential visitors. Health checks, checking people's temperature, self-reporting of symptoms, provide breaks to wash hands if that's not already in there. You close off areas for 24 hours first before you go in there because there's the aerosol spray is still lingering for at least 24 hours. If there is someone who has COVID or suspected of having COVID, that you need to do that before you do any type of cleanup. And you need to close off common areas such as like maybe elevators if you have that, and you can use stairs instead, or a kitchen area, or maybe even a copier where, let's say, people congregate to talk about that. And you cannot have meeting spaces of more than 10. So again, this is all orders based on the industry for that particular, for the city of St. Louis. So that's orders, that's law. Then you have the Centers for Disease Control, which is works with epidemics and viral situations just like this. And they have hopefully the best medical advice at that time. And then they would give guidance on what you need to do as an employer to go ahead and clean up your space, what you need to do to kind of do it. So you would go ahead and possibly should follow guidance. And there's a reason why I want to say you should follow the guidance. And we'll become clear very soon. Okay, so then there's also state and county guidelines or protocols for returning to work. That again is guidance. So in previous slides, I just showed a couple of things that was in order for, let's say, retail. Didn't give very much information. So what you would probably want to do is you look at that industry on your jurisdiction. Look, first of all, at Missouri. You look at what county you're in. I'm just showing the 3 of them. And you look at what the guidelines are. And then they will show, based on your industry, what you need to be following. Okay, so there's a reason why you want to do this. So kind of taking a look at all of these things and seeing if there's a lot of overlap. Now, on top of this, there's not just law with the executive orders, and there's not just guidance, but there's also something under the OSHA, which protects workplace safety, that they have law and guidance. So you have to follow this. And they divide workplaces based on exposure risk to the COVID virus. And so there's 4 of them right now. Very high would be anything like a hospital, medical postmortem, like a morgue, a lab that is suspected of or has had COVID around there. So anyone who's working in healthcare and morgue workers, that it's a very high exposure risk category to getting or catching COVID. And so what you need to do is follow that advice, that law and guidance that OSHA has on their website, which is I've provided at the bottom of the screen here, to see if that is your industry, you follow what those particular requirements are, protocols. Then high risk of exposure is, let's say, healthcare delivery, healthcare support, medical transport, and mortuary workers. So if your business is involved in somehow in healthcare, and they might be around those that have COVID, that's a higher risk. Okay? So maybe depending on if, let's say, an assisted living center, 117 assisted living centers in the state of Missouri that's had some sort of COVID, they would probably be under very high, right? So high would be a different category and lower on the spectrum. Medium, so jobs that require frequent or close contact with people who may be infected, but you don't know because a lot of people may be asymptomatic. So general public, like schools, close working environments, some high volume retail sales, maybe like a grocery store would be medium perhaps, but those that have frequent interaction with the public that you might not suspect have the virus. And so you follow those, what OSHA says there. And then of course, lower risk are those maybe that do not, those places that do not require contact with people known to be or suspected of having COVID, not around the public. Maybe a lot of offices might be in that particular category. So you want to go ahead and take a look at what OSHA says if you haven't already. So I've used this from the state, and this is just the general guidance. And of course, you would take this based on what the state says, the CDC, OSHA, based on your exposure category for your industry. And then also look at the guidance or the protocols that the state and the county have for your specific industry. So I'm just doing this right here. So you look at your business, you go ahead and find out what those risk categories, what you need to do, put into place protective equipment, have temperature checks, do more sanitation, you clean things up. This is just taken directly from the governor's or the state's website. You change physical workspaces to increase social distancing. There might be something said in the CDC, for instance, or with OSHA about types of where airflow comes in. And because everything's done, a lot of things are, COVID is transmitted a lot by air and we don't see it. Decrease or eliminate business travel. What you should be doing once you've kind of looked at those things is create a plan of action of what you're going to do, create some policies, some rules, some things that how your business is going to operate when people are coming back, and then what people need to do when your employers or employees come back to work. What do they need to do? What is this? And then also what happens when they test positive for COVID-19. So you have that in place. Hopefully you already are looking at your policies and such and able to take a look at this. Then you also want to put into place procedures that check for COVID symptoms, Don't allow symptomatic people to physically return to work until cleared by a doctor. You want to make sure that you get a medical professional's note on this. And then once you get your plan together, you've cleaned up your workplace, you have your plan, you talk to staff, you train them, you let them know what exactly all this is and how they're going to operate. And so some of the things that you need to be considering, what the state suggests, is can your staff work from home if possible? Maybe they're already working from home. Be open to how you operate your business. Maybe there's different ways of doing it to provide and maximize safety for your workforce. Maybe have working in shifts, having maybe 2 or 3 shifts during a day, or maybe having times of the week where people come in so that they are not in the same place at the same time, right? And so maybe some people can work from home part of the week and some people can work at the workplace the rest of the time. Limit access to common areas workers go. Again, bathrooms, copiers, places that people tend to congregate, elevators. Check your sick leave policies if you have them. Are they flexible? Are they up to date with the public health guidance that has been provided? And we'll talk about that as well. Okay, so in particular, you want to create and update rules and policies in your workplace. That's what attorneys are there for as well, that we're able to help you figure out what you need to do if you have some questions on how to put into place your policy in your workplace so that you can eliminate as much as you can any chance or risk that your workers will get the virus or spread it. So again, as I mentioned, you want to prepare your workplace. So things like having Lysol, having certain wipes ready, some hand sanitizer for everybody, having lots of this, making sure people are wearing masks, having all of this available, cleaning up, having some protocols of how you're cleaning it, and following the advice that OSHA, CDC, the state, and local authorities require. Creating those rules, provide training. That is really important because once you communicate this to your staff, you go ahead and train them and hold them accountable. Follow your policies. Okay, I'm going to mention that a little later too. So if you have all these in place based on this, you should be able to get your workplace back to some sort of normal, all right? So the second part of this, we're going to be talking about avoiding staff issues with COVID-19. Now, just because you might be following the law, the guidance, protocols, you've done all the stuff, you've bought all these things, you've created social distance, you have the policies, you've done the training, etc. But what happens though, if you have people who do not want to come back to work? They are scared. As I was mentioning to my team earlier, that as you may know, that Americans and people worldwide, the evidence or indication of a high amount of anxiety and depression and stress has happened because of the fear of getting in contact or catching the virus. So, you want to make sure that the first thing you need to do, obviously, if you're a business, you want to make sure that you are successful, but you do not want to risk your staff from getting this. You want, at the top level, you do not want to risk staff safety. You want to make sure that they are ready to go, that you're doing the best thing you can to make sure they feel more comfortable, that they're returning. And then if people are not doing what they're supposed to be doing after you've trained them, you've communicated it, then you'll need to go ahead and follow up and make sure that you are not seen as allowing things to happen and causing problems or risking people getting sick. So, if let's say you have some staff that are on unemployment right now because they might be making more on unemployment right now, enhanced unemployment benefits, than they were maybe working for you. And so you don't want to force people to come back if you've laid them off or something, and you don't want to be seen as interfering because that could be a problem in and of itself. You also don't want to risk having a bad working relationship. This is a time that communication and working together is very important. And so you do not want to make your staff angry or feel minimized and feel hurt and scared. And then if that happens though, guess what happens? Unhappy staff complain, and they complain they make complaints to the county health department, to the state, to OSHA, all right? They can file a workers' comp claims. So you don't want to do that. And they say that, that my employer, is not doing this properly. And I feel scared, okay, that I do not feel ready to come back. And what that happens means that eventually, if not immediately, authorities will come and enforce compliance, and that will not be good for you. So do not risk staff safety. So there are some legal risks to forcing employers to return that have been kind of around even before the virus. So first of all, there's something in general called whistleblower retaliation. So if there is something that their staff is scared and you didn't do something, or they're alleging you didn't do something right to kind of keep your workplace safe, and you have done something in response, you retaliated, maybe you've been angry at them, and that you've done something negative, like you've taken away their hours or fired them, or you demoted them, or something like that, then they have a right under some various different laws to go ahead and have protection for whistleblowing, blowing the whistle on you. So you want to avoid that. Okay, so there's OSHA has a complaint form that you can go online and a worker can go ahead and file that, and you don't want that. There's also, since most people who are employed are at-will employees, that means that they can be hired or fired without any notice, without any really real protections. But there's a public policy exception to that, so that if they see that there's a danger involved with the workplace and they're an at-will employee, then they could be saved from being fired. And if they are fired and they decide to file a lawsuit or whatever, then that could be a big risk for you and your business. There's also Workers' Compensation Act. The state has a Workers' Compensation Act, and that you need to follow that. And then also if you're a covered employer where you have a union, part of your staff is unionized, you also have to be careful of the National Labor Relations Act. And then generally that under workers' compensation, if your staff have whistleblower protection, they say that there's negligence, that you were not doing something you're supposed to do. Usually workers' compensation is the sole source to go ahead and complain about these things rather than filing a lawsuit. So you just want to be careful legally that you could be opening yourself up to a lot of liability and pain. Okay, so there's staff fears refusal to work. So basically there's an implied right for employees that generally employers are required to provide a workplace free of known hazards that cause serious harm or death. This also includes imminent danger, and COVID comes into this. So that if they fear that there are some known hazards, COVID, and you haven't done something, that means that they can go ahead and be protected and file something against you, and that would be bad. So basically, OSHA requires or allows staff to refuse to do a test, maybe coming back into the workplace, or maybe doing a particular type of work after these things have been satisfied. So let's say, in good faith, staff have asked the employer, you, to eliminate the danger, and you have not done that. Okay, they just said, okay, I don't want to be near other people, so I want you to have me on the only person on this floor on a 3-story building. All right. And you said, no, I don't think that's going to be really good because we really need to have people coming back in. No. Refusal to work must be in good faith, meaning that the staff member has a genuine belief that an imminent danger exists. I think in most circumstances, COVID would probably apply. So if they found that you're not doing something according to industry standards or what is required under the law, and they think, okay, we can do this, you're supposed to do that. It doesn't say anything right now about having one person on a floor. That's ridiculous. So then you look at this other one, the third party, a reasonable person, a person outside of your business, independent observer, would agree that a real danger of death or serious harm exists. So if I'm using that example of someone wanting to be all by themselves on one floor of a building, Would that be something that, if you do that, would it be a good idea? Is that something that if you have other people there, would that be risking it? I don't know. So it's kind of a factual situation. And then not enough time exists to get it fixed through regular enforcement channels. As you might expect, OSHA and other agencies around the country have been inundated with lots and lots of complaints about this very same thing. And so it's going to take a long time for OSHA and others to kind of respond to it. And so this is kind of a quick look at saying, what can I do as an employer to avoid these things? Is this a good faith reason? And OSHA will allow this if all these particular factors are met and that we can not come into work. Okay, so that is if those 4 things are satisfied. Now, what about looking at what is entitled? What is your staff entitled to do if they can stay home, if they don't work? There are some things that have been in existence since before COVID, and that is the Family Medical Leave Act. If you are a big enough employer, I believe you have to have, you have to have this, and people have to have been there for at least 180 days, I think, in order to have the act apply to them. And then if they have a serious medical condition and they're unable to work because of it, then they can go ahead and take unpaid leave, right? And that's still in existence. But then there are 2 other things that you need to take a look at, which happened with the CARES Act that was passed when we had this big Paycheck Protection Act and everything else. They had these other things that had been passed that Congress decided. One is the Emergency Family and Medical Leave Expansion Act, and that's a nice long EFMLEA, and that gives another reason to not come in, have unpaid work. You don't work from home, you're not working at all, but you have your job at the end of this, right? And you're unable to work or work from home because the employee is caring for a child whose school or place of care, child care is available, something like that. That there's something due to COVID that they're unable to do this. Now, the ones with asterisks, the first one and the second one, are only for under 500 employees, and it's eligible from April 1st to the end of the year. So this is kind of a very short-term solution. And the first one is unpaid. The second one is the Emergency Paid Sick Leave Act. It's that you're unable, the staff member is unable to work because they or someone they're caring for is under isolation or quarantine by a doctor, or they're advised to do so. Like, okay, you suspect that you might have COVID until test results come back, you're going to order to quarantine. If you're experiencing COVID symptoms and seeking a medical diagnosis, okay, you are seeking getting tested. And then also, or if you have someone who's caring for a child whose school or daycare is unavailable. As you know, the state of Missouri has closed all schools for the end of the year, end of the semester, which I think is May. And I think they're allowing summer school to open. And so, as you also saw earlier, that some daycares, if they follow CDC guidelines, can open. So that would have to be in play. And you can get paid sick leave, and there's some certain qualifications for it that we can always talk after this. And then that would be something that you could go ahead and maybe offer. Don't target anyone in particular, but you would go ahead and offer this to your staff if you haven't already, if it's applicable. Now, of course, those 2 that we talked about, if it's an independent contractor or a volunteer, then they probably would not be eligible for this. Now, what about fears of getting the virus? Okay, so you've done what you think you've done. Okay, you've cleaned according to guidance and the law, and you're getting your workplace ready, and you want to look at these particular factors. One of them is the workplace a low, high, or very high risk place? Okay, so is there a reasonable fear of getting the virus? Okay, looking at this, asking yourself about that. The other thing that I would also recommend is, what precautions did you take to get rid of the risk? So did you follow all the guidance, all the rules? Are the staff able to keep at least 6 feet apart? That's important. And then lastly, does your staff have pre-existing health conditions or are considered high risk? Now, okay, we're going to talk about that in a second, but if someone is considered high risk, they might not show that they're high risk, okay? You just don't necessarily know that. And it would not necessarily be a good idea to ask each staff member if they're high risk or not. Okay. So that's kind of what's going on with the looking at those factors to see if there's a reasonable fear that staff are not wanting to come back to work. So if you hear this, don't act against the staff for making complaints. When you do make a decision about a staff member, write down your reasons as you make them. Do not necessarily give opinion, but you go ahead and just say, this is what I needed to do. I had to get rid of this shift. And so as you make a decision that involves employees, that you have backup, you have documentation. And then if you do get notice from the authorities, respond promptly to OSHA complaints. And so there is a complaint form right there that's online. And they're saying that OSHA requires that unless it's a medical involving health or medical, something like that, that you want to go ahead and do it by letter, by email, or by letter, rather than on their online portal. Okay, so one of the things that you also want to be careful of as you're going along with all of this is, and that's going to apply all the time, even before it happened before COVID, it will happen after COVID. You have to avoid discrimination and liability. Okay, so as an employer, you must follow the law when reopening, and you must make sure that you're not discriminating, that you're not retaliating, and you're respecting seniority, meaning that you have staff members who might have been there longer, and you respect people who've worked for you longer versus those that maybe have been there sooner. So you want to go ahead and keep seniority when making decisions. When you have policies, follow them. It doesn't really make any sense at all if you have policies and you don't follow them at all. It will really hurt you in the end and look for liability if you don't follow your policies. And then when you're making decisions, make sure and use objective standards. Don't use like, well, I think this or I think that. You want to make sure that you're basing this on a really good reason that's based on law and all that. Okay, so I want you to be able to avoid these types of discrimination. All right, so I took this from the Missouri Human Rights Act, and these are the different categories that they say are protected. And so you want to avoid discriminating against people anytime in staff members. Intentional discrimination under various laws like the Pregnancy Act, the ADA, the ADEA, Title VII, Civil Rights Act of 1964, 65. So that's where you have done something on purpose because of one of these possibly protected categories and made a decision that was not good to them. So let's say you decided because you made some sort of statement, well, I don't like this Wuhan virus or this Chinese lab, or you make these types of statements, or you have these types of decisions, make these decisions based on maybe national origin or ancestry or something like that. Not a good idea. When I'm talking about seniority, if you have someone who's been there for a long time, and maybe they're older than a newer employee who's younger, you don't want to make a decision that's detrimental to the older person just because you think they're old. Okay? That is not a good idea. There's also something called unintentional discrimination, and that means that you might be doing this against a group of people, making decisions or saying things, and you don't mean to hurt them. You don't see it, but it's usually after the fact that, oh, looking back at it, oh, I made this decision as the employer. And so you want to ask yourself two questions. Does your use of neutral factors, like your decision to do X, Y, or Z, negatively impact a protected group? Okay, ask yourself that. And then secondly, if that decision to do X, Y, or Z, is that factor job related? And is it necessary for business? They call it the bona fide occupational qualification, BFOQ test. So is that related or essential to the job? And then you can make those decisions that might have some sort of impact on maybe gender or age. So going back to the helping high-risk staff. So there is, under the Department of Homeland Security, had a definition of high risk. And that was originally because of the travel from other parts of the world to the United States. They had to identify possibly who was considered high risk. And this is not inclusive. I just kind of gave you 8. So what does high risk mean? So it has these particular ones here. I'm not going to read them here. Let's say you have staff that might have these. You don't necessarily know if someone has high blood pressure, okay, or they have diabetes. You don't want to go and say, oh, Johnny, Susie, you look old, you look infirm, you look like you have asthma, you look really fat. I think that you need to stay home. You don't want to do that. What you want to do instead is go ahead and communicate to your staff, hey, if you're high risk and if you follow these particular categories, come to us, come to me, talk to me, and we'll see if we can work out a solution. You don't try and identify people on their own, have them come to you. You have to communicate it. So you can offer high-risk staff these things: a modified work schedule, changing where they're working. Maybe they can work from home. Maybe you can remove or reduce certain job duties that are not essential. You can create physical barriers, right? And you can offer a leave of absence, either as an accommodation, if they have a serious health condition, or something like that, or under FMLA. But all of these, if they come to you and say, I believe that I need to kind of have some modifications, require a doctor's note document, okay? So before we open this up for questions, I'm going to go ahead and give you some very broad takeaways. And I know that I've covered a lot of very general information in a short period of time. But first of all, follow the law. Look at the guidance, follow that. If you are not following guidance, and that you should be, especially according to your industry, that will probably come back to bite you later. So it's probably a good idea to reduce as much liability as possible by following along guidance of the CDC, of OSHA, not fouling up Workers' Compensation Act, state and local authorities. Avoid discriminating against protected groups, whether you mean to or not. Be careful what you say, be careful what you do. Develop a prevention in COVID-19 plan. So you have something to prevent the spread of COVID. You have a response, a plan of how you're going to respond if someone in your workplace has COVID or is suspected of it. Train your staff, go ahead and use the policies. Don't just ignore it. And follow up when people, if you've trained people and they're not following up, you'll need to go ahead and have some sort of a discipline against them if they have not been following these practices, because you are ultimately in charge of their safety at the workplace. Make sure you have safety controls in place, practice good social distancing, facial coverings, and follow your industry guidelines, and then communicate early and often with your staff and listen to what they have to say, because that is really important in order for all of us to get through this successfully. So.
Okay. Thank you, Tracy. At this time, we're ready to take your questions. If you have a question, please feel free to ask it here in the chat, and Tracy will try to address your question. As a reminder, please do not share any personal details in the chat. Okay, well.
Uh-oh, hopefully you can hear.
So, we do have a couple of questions already.
Okay, so let's go ahead and do that. So if you're interested in becoming a client, Richard will be happy to talk to you about this afterwards. So yes, please go ahead and let me know what might be there. Yeah. What kind of questions do you have?
First question was when you were talking about the ESLA and the EFMLEA. So when is the end of the ESLA or the EFMLEA?
So it's very hard to understand what you're saying, Marlene, but I could kind of tell from the different, FMLA and EFMLA and some of those, when do they come into effect? It basically is, those are very, very particular. And let me see if I can find this. Okay, so basically, the Department of Labor has these temporary regulations. They're probably going to change, so you need to go ahead and check them out. So basically, the emergency PSLA entitlements is that if they are, they're entitled to leave for 6 reasons. And they have, but for COVID happening, basically, that they would still be able to work, okay? So Usually you have to have employers that are smaller than 500. I think there's a special policy exception for those that have fewer than 50. So I think they're mainly looking at if you have fewer than 50 employees, then you're probably going to have to ask for an exception to this. And I believe it's the same thing with the other emergency family medical leave expansion. So, and then there's also some talk right now in Congress about maybe something happening with childcare and having some paid childcare so that parents can go back to work in the workplace, if that's a possibility. So I'm hoping, are there other questions that people might have right now?
Yeah, there is. What about staff members who live with or are caring for high-risk people?
So staff members who are caring for high-risk people, is that right?
Yes.
Let's see, it's very hard to hear you, but let me see if I can go ahead and stop sharing for a minute or seeing what chat says. My apologies. Yeah, so if people are caring for people who are in high-risk categories, then you should be protected to ask for modification or changes to coming in, because you don't want them to be exposed to the virus. And so those, again, about staff entitled to stay home, there's some that are, as I said, that are under the FMLA, the Emergency Family Medical Leave Expansion Act. Both of those are unpaid, but emergency paid sick leave, if you don't have sick leave policy or paid sick leave for your staff, this is an opportunity. And part of it is they are caring for someone who is in one of those high-risk categories. They can go ahead and use that if you are an employer who is within a certain number. So you have to have, there's so much there. If you have so many, but it has to be under 500. Independent contractors and volunteers are not counted. So you go ahead and let them know that this is available if you have that, and go ahead and put that together by document. I wish that I could give you more detail, but there's a lot of information out there on those particular acts. But I can go ahead and give you some more detailed information offline and get back to you as well. What other questions do we have, Marlene, at this time?
I do not see any other from any questions, but I have a question if you have time to talk about one more.
Okay. If you have a question that you want to talk about, I think I'm understanding what you're saying. And which is?
What if an employee comes to work and has now been told that he or she might have COVID, or might have been in contact with someone with COVID, and then be tested?
Okay, so I think I understand what you're saying, and I have to translate a little bit because not coming in completely clearly. That if you are in a workplace where someone at work has been maybe considered having COVID or being tested for it, and they are in close proximity, depending on what level of exposure, if it's high risk, medium high risk, high risk, very high risk, medium or low risk under OSHA risk categories. If that's the case, you look at that and you say, okay, probably you look at that, you look at the state, you look at the city, you look at CDC and your industry, and you say, okay, if someone has been either tested or that they are suspected of having COVID and they're in the workplace, have been in contact with anybody else at work? I don't believe there's any problem with letting people know, your staff know, that someone is being tested for COVID, unless that you are a covered employer on like a hospital or a medical provider that deals with PHI for under HIPAA. So generally for you can go ahead and for public safety, you should probably clean. You should go ahead and keep that area where the worker was away from everybody else until you know for sure that they've tested for COVID, and wait 24 hours to go ahead and clean it. And you do a very big cleaning protocols. Follow the protocols that are required. You let other people know, your staff know that this has happened. You don't necessarily have to identify who it is, but it would probably, depending on the size of your workplace, might be a good idea. And if people have been closer than 6 feet, or there's a suspicion of it, that they might want to quarantine as well. So this is where, if you as an employer are following all the guidelines and you're cleaning everything, and you need to communicate with your staff, you can't just let it go. Because again, going back to the beginning, if you don't do what you're supposed to do, you don't communicate. Let's say you don't require masks in the workplace, or they're closer than 6 feet, and there's really no reason for them to be closer than 6 feet, and you don't tell anybody, then that's going to be really bad for you, because then you can go ahead and have an OSHA violation. You can go ahead and whistleblower, go ahead and they can file a complaint with the state or the county health department. And so I think you're also obligated to let them know, and then they have to do contract tracing. So again, look at your policies of what you have. If you haven't already developed it, you might want to enlist an attorney to go ahead and help you with it. So Marlene, are there any other questions at this time? I'm going to go ahead and mute and see if Richard.
I'm not really hearing anything from Richard, so I guess we're done today, but thank you everybody for joining us. As a reminder, today's session will be saved on our Facebook page.
Thank you so very much, Marlene and Richard, and thanks to you for being part of this webinar. And again, if you have other questions, please don't hesitate to reach out to us at ced@lscm.org. Thanks, and have a great day.